I see lots of folks jumping in the waiting room, jumping into the agenda. Super excited to see people joining. I'm going to give everyone just a couple more minutes. I know we're 2 minutes past the hour. I just want to make sure everyone has an opportunity to fight through the technology and get into the Zoom call, and we'll be getting started. But if you are here for the SCOTUS Salon, you're absolutely in the right place. Thank y'all so much for being here. If you are just jumping in, thank you so much for joining. If you're here for the SCOTUS Salon, you're absolutely in the right place. Just waiting one more minute to make sure everyone has had an opportunity to get in from the waiting room and all the other places. And we are going to get started. Awesome. So we are 3 minutes past the hour. Gonna go ahead and get started here. Welcome, everyone. Thank you so much for being here. My name is Taylor Jones, and I'm the organizing director at Demand Justice. Thank you all for joining us for this really important discussion about the threats this Supreme Court poses to the LGBTQ equality in general, how reforming the Supreme Court can help to address those threats, and why court reform is an essential part of the broader push for democracy reform in general that we've seen kind of growing in the past few years. I want to get started by first thanking our partners, Lambda Legal, the National Center for Lesbian Rights, and Freedom from Religion Foundation for joining us tonight. Thank you all so much for being here. We're so excited to be able to hear from each of you and to be in this fight with all of you in general. So I'm really looking forward to this conversation and jumping in with you all. But before we hear from you, we're also really lucky to be joined for some opening remarks by Congressman Mark Takano. So Congressman Mark Takano grew up in California's 41st district, which he now represents. He also served as a public school teacher there for 2 decades before becoming the first openly gay person of color to be elected to Congress. There he now serves as the co-chair of the Congressional LGBTQ plus Equality Caucus. He is also chairman of the House Committee on Veterans Affairs. And he is a member of the Education and Labor Committee there. He has been a tireless champion for progressive causes his entire career, honestly. And I am happy to say he was one of our early co-sponsors for the Judiciary Act of 2021. As you may know, a game-changing bill which would add 4 seats to the Supreme Court. Congressman Takano is also vice chair of the Congressional Progressive Caucus, which in January endorsed the Judiciary Act as well. Let's take a few moments to hear what he has to say.
I'm Congressman Mark Takano. I represent California's 41st district, which includes the cities of Riverside, Paris, Moreno Valley, and Hoopa Valley. I also have the honor of serving as chair of the House Committee on Veterans Affairs and as co-chair of the LGBTQ Equality Caucus. I'd like to thank Demand Justice, Lambda Legal, the National Center for Lesbian Rights, and the Freedom from Religion Foundation for hosting these SCOTUS salons to draw attention to the Supreme Court decisions that will inevitably have an impact on all our lives. When the Supreme Court took the extraordinary action of overturning Roe v. Wade, they were unrestrained with regard to rolling back the constitutional and fundamental rights of women. Therefore, we should expect they will be unrestrained when it comes to rolling back the rights of other groups of Americans, indeed all Americans. Simply put, the Supreme Court has gone rogue. It has become a radical institution that does not reflect the will of the people. That's because for decades, Republicans made their politics about taking over the judicial branch of government. They have only won the popular vote in one of the last 8 elections. Yet, they have appointed the supermajority, currently threatening to strip you of your rights and me of mine. Justice Thomas has openly suggested that the Supreme Court should reconsider other previous rulings, including the right to contraception and the right to same-sex marriage. So we should believe that overruling Roe v. Wade was not the end of their agenda, but the beginning. That's why in Congress, I'm working on legislation alongside Senator Brian Schatz to protect the rights to privacy and liberty granted by the Supreme Court decision, Lawrence v. Texas. This legislation would prevent any person acting under color of state law from inhibiting an individual's right to engage in private, non-commercial, consensual sexual conduct between adults. While the threat to reconsider the current interpretations of privacy and liberty affects everyone, it disproportionately affects the LGBTQ plus community, and I will not stand for it. Ultimately, millions of Americans could see a roadblock on their protected rights. We need to address the core root of this problem. I have been a strong supporter of the Judiciary Act of 2021, which would expand the number of justices on the court from 9 to 13. The Supreme Court has not kept up with the growth and diversification of this nation, and this is putting all of us at risk. The Judiciary Act of 2021 is the only way to restore the critical balance that the current court desperately needs. This is the only way we can preserve the rule of law and the rights we deserve. Reproductive justice is on the line. Marriage equality is on the line. Climate change is on the line. Gun safety is on the line. Getting money out of politics is on the line. Putting people over politics is on the line. It's up to us to make our voices heard. Thank you for doing your part, and please know I'll be doing mine.
Thanks again to Congressman Takano for speaking to us tonight. Now, let's get started on our conversation here. I want to take some time now to introduce to you our panelists. Joining us tonight are Christine Kippens, the Deputy Legal Director for Policy for Lambda Legal, Julie Gonen, the Federal Policy Director for the National Center for Lesbian Rights, and Sam Grover, who serves as Associate Counsel with Freedom from Religion Foundation. Thank y'all so much. So let's do it. Let's get started. We're here tonight to talk about the urgent need to reform the Supreme Court and to protect our rights and our democracy. I want to start this conversation with some scene setting around what the Supreme Court has been doing, just in an effort to kind of frame really the urgency of that need as it exists right now. So Christine, let's start with you. The bombshell this past June, of course, was obviously the court's decision in Dobbs versus Jackson Women's Health Organization to overturn Roe v. Wade, which has already led to 15 states instituting bans on abortions. As many know, Lambda Legal condemned this decision swiftly and unequivocally. Can you say a bit more about the case and about how it affects the LGBTQ plus community?
Sure, Taylor, happy to. So for everyone, let's begin with a little procedural history. The state of Mississippi enacted a 15-week ban, a pre-viability ban on abortion. So the Center for Reproductive Rights immediately challenged the law in federal court on behalf of Jackson Women's Health Organization, which was then Mississippi's last remaining abortion clinic. Thankfully, CRR won emergency relief the next day, blocking enforcement of the ban. About 6 months later, the same court struck down the 15-week ban because it violated decades of precedent holding that states lack the power to ban abortion before viability, concluding that, quote, the state chose to pass a law it knew was unconstitutional to endorse a decades-long campaign fueled by national interest groups to ask the Supreme Court to overturn Roe v. Wade. The U.S. Court of Appeals for the Fifth Circuit, and I'm going to say that again, the U.S. Court of Appeals for the Fifth Circuit affirmed the district court's decision in December of 2019. The same Fifth Circuit that constantly ignores precedent and procedure all the time. The court said, quote, in an unbroken line dating to Roe v. Wade, the Supreme Court's abortion cases have established and affirmed and reaffirmed a woman's right to choose an abortion before viability. When the Supreme Court granted cert in Dobbs in May of 2021, it sent shockwaves throughout the community. Just a year prior, Chief Justice Roberts sided with Justices Ginsburg, Sotomayor, Kagan, and Breyer to reaffirm abortion precedent in the case June Medical Services v. Russo, which concerned a Louisiana admitting privileges law that was practically identical to the Texas law struck down by the Supreme Court in 2016 in Whole Woman's Health v. Hellerstedt. It was not that long ago that the Chief Justice said such a law, quote, cannot stand under principles of stare decisis. What made Dobbs different from June Medical was the fact that Justice Ginsburg was no longer with us. And rather than allowing voters to decide who should fill her seat, Mitch McConnell and Lindsey Graham stole yet another Supreme Court seat from a Democratic president and ran through the confirmation of Justice Amy Coney Barrett, despite the fact that millions of ballots had already been cast for the next president of the United States who would have the power to appoint federal judges, including justices to the Supreme Court. So with yet another Trump judge on the bench, we knew it was only a matter of time that the Supreme Court would fill his campaign promise and overturn Roe. In Dobbs, Justice Alito, writing for the majority, overturned both Roe v. Wade and Planned Parenthood v. Casey, holding that the Constitution does not confer a right to abortion. Alito justified this claim, holding that the 14th Amendment makes no express reference to a right to obtain abortion, that the due process argument supporting the right to abortion as an exercise of liberty fails because the right is not an essential component of, quote, ordered liberty, because abortion is not rooted in the nation's history and tradition. We could have an entire panel on that sentence alone. And the court was not convinced that the right to abortion is part of a broader entrenched right, like autonomy. Alito goes into a lot of other nonsense, but those are the main takeaways. If you'd like to read what the opinion should have read, I encourage you to read the amicus brief of the National Women's Law Center, signed by various partners, including Lambda Legal. The bottom line is, the Supreme Court of the United States has sanctioned forced pregnancy, and they failed to honor what this decision means for people's lives, including LGBTQI folks. Queer people need abortion access too. In fact, according to the Guttmacher Institute, bisexual, trans, and non-binary people are more likely than their cis and straight counterparts to choose to have an abortion. So all the problems this ruling makes for cisgender women are the same for LGBTQI people who can get pregnant or go through surrogacy, which includes increased risk of low pay or poverty if they're denied an abortion, increased risk of unemployment and job discrimination, and increased risk of temporary or permanent health problems, including death, especially for Black women who are 3 to 5 times more likely to die from childbirth than white women. Denying reproductive autonomy compounds the generational trauma of people of color, individuals with disabilities, and LGBTQI people with histories of reproductive coercion and forced sterilization. Again, this is especially true of Black women who bear the legacy of slavery, forced sex, and forced childbearing. People in abusive relationships who are denied abortion are more likely to sustain contact with their abusers over time and be subjected to continued violence. Not to mention the harm to families. The majority of people who choose to have an abortion are already parents. This will cause economic strain, as well as time and resources diverted from the children they already have. And we're already seeing the effects of clinic closures and uncertainty around the law. For many trans, non-binary, and genderqueer folks, abortion clinics are the only place where they receive gender-affirming care, as well as other forms of healthcare. Miscarriage management is affected because miscarriage and abortion present in the exact same fashion. Patients experiencing a miscarriage or delayed care, risking serious complication or death, while the legal department of hospitals determine whether or not the facility can provide care. This also creates a chilling effect, as people will be frightened to ask for medical care to treat a miscarriage because they think they will be assumed to be someone who has self-managed an abortion, and they risk being criminally or civilly charged with having an abortion. Medications used for non-reproductive reasons are being denied to folks who need them because they might also act as abortifacients. People are confused whether IVF is still legal in some states. And we expect about 26 states to ban or severely restrict abortion access in various forms over time. So Taylor, unfortunately, the extent of the impact of Dobbs just in the abortion sphere will be vast.
That, like you said, I think that there are many points that you made, Christine, that we could have built an entire panel around discussion on. I think you're completely right about that. And the idea that this is just a thing that, again, compounds the existing fears, dangers, and things that we all face as members of this community anyway. And the ways it impacts the other ways in which we exist and the way we live our lives. I think we talk about the dangers of a Supreme Court that has been captured by right-wing interest, but this, I think what you said grounds what that danger looks like in the everyday lives of folks. And I think that's what's important to talk about here. So something that you said, I think, brings me to my next question, which is for you, Julie. Each of the court's 6 conservative members joined the decision to let the anti-abortion law in Dobbs stand. And 5 of the 6 joined the majority opinion to overturn Roe v. Wade outright. But in various consequences, a split seemed to appear. So Justice Kavanaugh wrote separately to suggest that the decision in Roe would have no bearing on other related rights, such as marriage equality, sexual privacy, and contraception. But Justice Thomas wrote essentially the exact opposite. What does that disconnect say to you about the conservative majority on the court? And how imperiled do you think all of these related rights really are?
Well, thanks for that question, Taylor, and thanks for the invitation to be part of this really important conversation. It's a really good question. I mean, concurrences, as we know, are not totally uncommon in Supreme Court decisions. They're not usually 9-0, and even in the side that prevails, there are usually different takes on it. But I think there are probably a number of reasons for the disconnect that you pointed to among the various opinions that were in the majority in striking down Roe and Casey. I think some of the justices probably generally do believe that abortion is just different, right? We hear that a lot. That argument doesn't really hold up that well logically. There's a wide variety of opinion around the morality of contraception too. There are some who equate certain types of birth control with abortion and find them equally unacceptable. So it seems like the court was really elevating the views of some members of the court in order to remove Roe and abortion from the protection of stare decisis, or the respect for precedent, and the long line of cases in which Roe is situated. I'm sure some of the justices were undoubtedly aware that overturning Roe would cause such a firestorm, and they wanted to limit that firestorm to just abortion rather than suggesting that they're coming for other rights next. And I imagine some of them were probably aware that what they were going to do in Dobbs would lend fuel to court reform efforts. And they were right. At least Justice Thomas was fairly open about where he stands. He has always been a pretty vocal opponent of this whole doctrine of substantive due process, which is the doctrine that says that there are fundamental rights in the Constitution that have to be respected and the government can't trample on. He's always hated that doctrine, says it out loud, said it here, and he openly did call. He was the only one who did this. He's the only one. He called for other precedents around personal rights to be reconsidered. So the cases you mentioned, there's Griswold, the right to contraception, Lawrence v. Texas, the right to personal intimate sexual relations, and of course, marriage equality in Obergefell. I think what this disconnect overall reveals is that all of the justices are well aware that Roe is one piece of a larger interconnected jurisprudence around personal rights, and that it really can't just be extricated without causing harm to that entire field of cases. They all felt that they needed to address that in some way. I mean, they were very aware of the really monumental thing that they were doing. You know, Justice Thomas mentioned those 3 particular cases, but there are other rights in this line of cases too. The right to raise children the way you see fit, the right to live with extended family, the right to bodily integrity, which includes the right to refuse unwanted medical treatment. Roe was in the middle of a long line of cases. It built on prior cases, and then other cases rest on Roe itself that creates sort of this whole body of rights around personal autonomy. Now, as far as what it means for LGBTQ rights, I don't think for a minute that this court would turn away a challenge to Griswold, Lawrence, or Obergefell if one came its way, and they probably wouldn't hesitate to undermine or overturn those precedents. That said, it doesn't mean that such a challenge will be at their doorstep in the immediate future. It takes a while for cases to reach the court, and there's widespread support for the rights that are recognized in those cases, the right to access birth control and to marry the person of your choice. Of course, there's also popular support for abortion rights. So popular support doesn't necessarily get us all that far, particularly when the court is wedded to this notion of history and tradition that I think Christine touched on, that's the metric by which we measure whether a right exists. I think right now what we need to do is kind of walk and chew gum. We need to keep the focus on abortion because that's what has been taken away and people are being harmed right now, as Christine said. At the same time, we need to reject the false reassurances from people like Justice Kavanaugh and be vigilant because LGBTQ rights very much are in the crosshairs.
Yeah, I think that's important. I think that there are people who will say that it is fear mongering to say that it is wise to be mindful and to look down the line. But I think we do have to think about the things that they've already said about the precedent that is set and that they follow, and the things that have already been talked about. So I think that's something really important to highlight. Thank you for sharing that. Sam, my next question is for you. So the court decided 2 religion cases this term, in one allowing public school officials to lead prayer in schools, and in the other forcing public school districts to fund explicitly religious education. Can you say a little bit more about each of those cases?
Yeah, absolutely. First, thank you, Taylor and Demand of Justice, for having me and the Freedom from Religion Foundation on this panel. FFRF has been a strong advocate for abortion rights and LGBTQ plus rights. So we're happy to be a part of this conversation. So the first of the 2 cases that you just referenced is Kennedy v. Bremerton, where the court granted a win 6-3 for Joseph Kennedy, who's a former public school football coach who engaged in public Christian prayer at the 50-yard line after football games. Now, it's unclear exactly what precedent the case will have moving forward because the court had to contort and narrow the facts in order to serve Kennedy a win. The case does not say that public school employees can pray with students while on the clock. The court set aside Kennedy's locker room prayers and any prayers involving his players, which he did engage in the past, because he voluntarily ended those practices when the school caught him. Instead, the court ruled only that the school couldn't prevent Kennedy from praying after his official duties had ended, after the game had ended and the players were away from the field and he moved to the 50-yard line. That's not how the case is being interpreted by public schools that are opening up now for a new school year all around the country. And that's certainly not how Christian nationalist advocates are pushing the case. So we are certain to see a lot of bad behavior from public school officials this coming school year because of that. More importantly, in Kennedy v. Bremerton, the court did away with the traditional Establishment Clause tests, both the Lemon test and endorsement tests that have served as the foundation for a lot of Establishment Clause protections in the past. So it wrote instead that the Establishment Clause must be interpreted by reference to historical practices and understandings, again, a reference to history and tradition. And while the court didn't actually undertake any historical analysis when ruling for Kennedy, the takeaway from this case should really be that the court is willing to do whatever it can to uphold Christian privilege and turn quote unquote religious freedom into a right to push religion on others. So writing in dissent, Justice Sotomayor criticizes the majority opinion for ignoring the history and context that led to Kennedy's prayers at the 50-yard line, including his years of pressuring student athletes into prayer. And she writes that the majority all but ignores the Establishment Clause in its pursuit to expand free exercise rights. And that is a theme that unfortunately we're bound to see more of in the future. The other case that you mentioned is Carson v. Macon, where the same 6 justices overturned Maine's no aid law, which prevented taxpayer money from funding religious indoctrination and proselytization at Maine's private schools. So Maine has many rural areas without the resources to have their own public school. And so Maine has put a tuition assistance program in place to help students attend private schools provide an equivalent to public education. And religious schools were not categorically prohibited from receiving funds under that tuition assistance program. Only schools that explicitly indoctrinate students were excluded, right? So as long as you are teaching the equivalent of a public education, you can get this taxpayer money. But if you want to indoctrinate students, that's your business as a private organization, but you can't receive public funds. The Supreme Court went against longstanding precedent in ruling that if Maine elected to fund some private school education, it could not prohibit taxpayer money from funding religious education as well. The problems with this are manifest and specific to the 2 Christian schools that served as plaintiffs in the case. Both of these private Christian schools admit that they discriminate openly against LGBTQ individuals and against non-Christians. So that's currently the state of those Supreme Court cases and the decisions this term.
Like you said, that marriage to history and precedent that has been kind of a continuous thread through this conversation, I think is an important thing to note. So Christine, my next question is for you. This intermingling of public education with religion, as Sam just talked about, affects every single student, but the impact is felt usually disproportionately by non-religious students. As you said, those who they have very clearly spoken out against, students who practice minority religions and LGBTQ plus students. Can you speak to the very real and imminent harms that more religion in schools may cause those students right now?
Yes, the impact can be devastating, especially for LGBTQ students and children of LGBTQ parents. First off, I think it's important to say that public schools bring together young people from various backgrounds and traditions, including some LGBTQ students who are religious, agnostic, atheist, and some who are still trying to figure out both their spirituality and their identity. These are formative years, so it's critical that public schools be a place where students feel free to be themselves, to discover and manifest who they are and who they wish to be, and be affirmed in that road to discovery, free from imposed government-sanctioned religion and beliefs. Because when the opposite happens, these students risk suffering from insider-outsider dynamics that are propagated by school-sanctioned prayer. So the Supreme Court had long been concerned that religious activity on public school grounds by public school officials creates an insider-outsider dynamic among the student body, faculty, and school staff, where the religious majority may receive or be perceived to receive benefits that non-conforming people do not. It's also important to name that many LGBTQ students and families struggle with rejection by certain religious denominations. LGBTQ students, whatever their own faith beliefs, often see their identity, their existence, and their place in particular religious worldviews debated, if not denigrated, on a local, national, and global scale. These harmful debates and decrees create anxiety, if not fear, for many LGBTQ young people. So when the government appears to endorse religious beliefs that fault or exclude LGBTQ people, it's both gravely problematic and unconstitutional. For students who identify as LGBTQ or have LGBTQ family members, this perceived endorsement by government officials like public school teachers creates particular risks of adding to their sense of marginalization and alienation from the larger public school community. So the perceived or real government endorsement of religious practices that include religious rejection of LGBTQ people is likely to have the effect of making these students feel like outsiders. They're not entitled to the full privileges of what is provided by the school, and they're not true members of the school community. And such feelings of marginalization and alienation can lead to negative scholastic outcomes, including not completing high school, and they could go so far as to lead to increased suicide ideation. So by way of example, I'd like to share with you the story of Jessamine Morales, who is an active participant in Collage, the only national organization that builds power by supporting people with one or more LGBTQ parents or other caregivers. And Jessamine shared her story in a brief Lambda Legal filed with other LGBTQ partners in Bremerton v. Kennedy, the first case that Sam discussed. So Jessamine grew up in Midland, Texas, to not one, but two pairs of LGBTQ parents. Both of her parents eventually came out as same-sex loving and each married same-sex partners. When she went to elementary school, her school district required a minute of silent prayer each morning. And when she refused to participate, her teachers informed her that her non-participation was 1, disrespectful, 2, they punished her for her choice not to participate, and 3, they encouraged her to use her prayer time to counteract the ill effects of her parents' sexual orientation. Her peers, following the lead of their teachers, refused to socialize with her. In high school, Jessamine joined the swim team. Her coaches required her team to pray before each competition. And when she chose not to participate in a moment of prayer, her coaches threatened to remove her from the team. Her peers, once more taking lead from the authority figures at their school, they ostracized her. These type of events not only increase the difficulty of adolescence, which hormones and social media is already bad enough, but it can also impede, stunt, or even stop the spiritual growth of young dissenters. And I think Jessamine's story clearly illustrates that the authority and influence that school officials wield is powerful and can easily lead students to seek ways to ingratiate themselves to that authority, even if it means conflict with their fellow students that they care about, or betrayal of the students' own deeply held personal beliefs concerning their identity, their religion, or spirituality. And LGBTQ students and students with LGBTQ family members, for them, these coercive pressures can weigh heavily given the intensity of the current debates and decrees within religious communities.
Thanks, Christine. I think it's very real that what could be perceived as endorsement of those religious beliefs, especially where those things like may promote exclusion or even condemnation of students, especially during those formative years. I think you spoke to all the ways that can be really, really harmful, really, really dangerous, especially for young people. I think that just is one of those things, and these two religious cases that were taken up in this last term follow kind of a broadening trend of the conservative justices on the court to treat religion more favorably than the many other interests with which it has to be balanced, like Sam alluded to a bit earlier. This trend is often particularly harmful, not just to LGBTQ plus students, but to the LGBT plus community at at large. For instance, Julie, I want to talk about with you. Last year, the court ruled in a case called Fulton versus Philadelphia that the city of Philadelphia had to continue a contract with the foster care service agency, even though that agency refused to abide by the city's policy prohibiting discrimination on the basis of sexual orientation and gender identity. How did that case impact the future of anti-discrimination laws, especially those, but not just limited to those, that protect LGBTQ plus people?
Right. So the short answer is Fulton wasn't great, but it could have been worse. So in March of 2018, the city of Philadelphia ended a contract that it had in place with Catholic Social Services. And if it's okay, I'm just going to say CSS after this, because otherwise I'm going to keep tripping over that. They had a contract in place with CSS and other private agencies for screening parents and placing children in foster homes. But CSS had a policy of not licensing same-sex couples to be foster parents, which violated the city's anti-discrimination laws. So when the contract was terminated, CSS sued Philadelphia, asking the courts to order the city to renew the contract. They argued that their right to free exercise of religion and free speech entitled them to reject qualified same-sex couples simply because they were same-sex couples, rather than for any reason related to their qualifications to care for children. The lower courts found for the city, held that the city's non-discrimination policy was neutral and generally applicable, and those terms matter, and that CSS hadn't demonstrated that the city had targeted them for their religious beliefs or was motivated by any ill will toward religion. The case then went up to the Supreme Court, and at that point, Catholic Social Services asked the court to revisit a case called Employment Division versus Smith, which is a very important precedent from the Supreme Court, when the court held that as long as a law is neutral and it applies to everybody, it will receive rational basis review, even if it might have an incidental burden on religion. So rational basis is sort of the lowest bar that a law has to clear to be upheld. So in Fulton, now this was actually a unanimous opinion, which some might find surprising. It was written by Chief Justice Roberts, and they reversed the lower court. Supreme Court said that the refusal by Philadelphia to contract with CSS for foster care services, unless CSS would certify same-sex couples, violated the free exercise clause of the First Amendment. They said that what Philadelphia was doing burdened CSS's religious exercise by forcing it to either curtail its mission and not participate in the foster care program or certify same-sex couples in violation of their religious beliefs. So they said that the Philadelphia law was not neutral and generally applicable because it allowed for exceptions in certain situations to the anti-discrimination requirement at the sole discretion of the commissioner. It didn't matter that no such exceptions had ever been granted. The fact that it was a possibility in the view of the court made the law not neutral. So that meant that the policy where the non-discrimination requirements were going to be subject to strict scrutiny, and the government pretty much always loses when that's the case. So the court said that the question is not whether the city had a compelling interest in enforcing its non-discrimination policies generally. The question was whether it had an interest in denying an exception to CSS specifically, and the court concluded that it did not. So the court in Fulton didn't outright rule that religious exercise always trumps a compelling interest in preventing discrimination. But here's another situation like when we were talking about Dobbs earlier, where we had a number of concurring opinions by several of the justices who were signaling where they really want to go with this. So even though it didn't happen in this case, several of the conservative justices said that we really should be revisiting the Smith case and overruling it. Justice Barrett wrote a concurring opinion that actually Justice Breyer joined most of, I think all but one paragraph, saying that there were arguments for overruling Smith, but it's just not, this isn't the case to do it in. But Justice Alito, Thomas, Gorsuch wrote separate opinions saying that they would definitely overrule Smith and replace it with a rule that said any law that burdens religious exercise is always subject to strict scrutiny. So while Fulton hinged on the city's discretion and it left Smith standing for another day, the signs are there that the court is headed in a direction of tilting the balance heavily toward deferring to religious beliefs, even at the expense of third parties. And that is where the real threat to non-discrimination protections lies.
Yeah, I think that's helpful for just understanding, like you said, what the real threat is, and how that would exist and show up for all of us. I think a case that is helpful for kind of understanding what that looks like, is one I want to talk about with you, Sam. So the court has agreed to hear a case in its upcoming term called 303 Creative versus Elenis, which could even further limit state and local government's ability to enforce anti-discrimination measures that protect LGBTQ people. Can you tell us more about that case and what we might expect the court to do with it based on what we've seen thus far?
Yeah, sure. I'd love to do that. Just background first, 303 Creative is a website design company. It's run by a Christian who does not want to design wedding websites for same-sex couples. And if that fact pattern sounds to you a lot like the setup we saw in 2018 with the Masterpiece Cake Shop case, you'd be right. It's essentially the same. In fact, it's the same Colorado civil rights law at the center of the case. So if you'll recall, in Masterpiece Cake Shop, the court used the flimsiest of comments made by the Colorado Civil Rights Division to claim that the division had exhibited religious hostility, which allowed the court to punt, to not decide the question of whether a religious business can deny services to same-sex couples. That's not how the case was portrayed in the media. It was portrayed as a win for Masterpiece Cake Shop, and it was, but essentially the court wasn't ready to decide that issue. This time around, the court will most likely decide essentially the same challenge, although this time it's being considered only as a free speech claim and not a free exercise of religion claim. Now, the main factual difference this time around is that in Masterpiece Cake Shop, the owner had actually denied a same-sex couple's request for a wedding cake. And this time around, the website designer here doesn't make wedding websites at all. Now, the FFRF is filing an amicus brief this Friday, arguing that the plaintiff in this case lacks standing. Essentially, she's manufactured a controversy based on a hypothetical injury, specifically to push this Christian nationalist agenda of making discrimination legal if it's religiously motivated. Now, the court is undoubtedly going to decide in favor of 303 Creative, which signals a major shift in existing legal precedent. And this is really what I want. If you take away one thing about what the Christian nationalist agenda is regarding religious freedom, take away this. There has been a long line of cases seeking to do what 303 Creative is going to do in this case, and what happened in Fulton, the city of Philadelphia, and what almost happened in Masterpiece Cake Shop. What the religious right is trying to do is justify discrimination against marginalized groups based on religious belief. And this argument first came up all the way back in 1878 in a case called Reynolds v. US, where a religious group challenged an anti-polygamy statute based on religious freedom grounds. And the court rejected that challenge, saying, quote, to permit a religious exemption to the law would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. Government could exist only in name under such circumstances. Perfect reasoning, perfect outcome. Essentially, your religious belief, it's fine to believe what you want and practice what you want, but you can't violate the law when you're doing it. But that's not the last time this argument came up. It came up again in 1944 in a child labor case called Prince v. Massachusetts. And again, the court said, no, your religious belief doesn't give you an exemption to child labor laws. It came up again in 1968 in the Newman v. Piggy Park Enterprises case, where Maurice Bessinger said that it would, quote, violate his sacred religious beliefs to serve Black people at his South Carolina barbecue joint. And in that case, again, the Supreme Court had no problem upholding the Civil Rights Act against a religious freedom challenge. It happened again in 1983 when, in the case Bob Jones University, the United States, wherein the IRS revoked the tax-exempt status of Bob Jones University, the university founded by televangelist Bob Jones, because it wouldn't admit Black students. And again, the Supreme Court said, no, your religious beliefs don't exempt you from generally applicable civil rights laws. Now, in each of these cases, the Supreme Court rejected that argument that religious belief grants a license to discriminate. Now, however, the court, punted on the issue in Masterpiece Cake Shop and signaled its willingness to overturn existing precedent in a later case. And then in 2020, it finally sided with the religious freedom argument for the first time in Our Lady of Guadalupe School v. Morrissey Beru, which is an employment discrimination case where the court ruled that 2 elementary school teachers at Roman Catholic schools had no recourse after they were fired, one allegedly due to her age after working for the school for 16 years, and the other after she informed the school that she was undergoing treatment for breast cancer. The court ruled that both of these teachers fell under the ministerial exemption and were thus not covered by civil rights laws. And that's tangentially related to 303 Creative, but returning to 303 Creative, this case will drastically expand the idea that religious freedom and free speech can allow a business to become a law unto itself, granting it the power to ignore civil rights laws and discriminate against marginalized groups. And that's something that we should all be concerned with.
Yeah, I think it is fair that across like whatever groups you represent as you show up to this space today, I think that is like a really, really important note for us to like kind of focus on. I think the inevitability of all of our rights being really, really, really at risk, given lots of things that have happened. And what's important to note here is that these cases are not new. The cases that were heard in the last term, the cases that are being presented are not new. There have been these cases and the likes of these in the many, many years as Sam has just lifted up. What is different is a Supreme Court that is captured by right-wing interest. What is different is a conservative supermajority that is committed to the things that we've talked about here. So out of all of this sort of inevitability that we understand kind of our rights to be in great danger, leads the question of what to do about this out of control Supreme Court. I think the good news, my one shining star, is that all hope is not lost in these moments of righteous indignation. And I think like reasonable frustration daily with the general state of our union. What normally gives me like the safety to feel those moments of respite and do good things every day is knowing that all hope is not lost and that there is something that has material gain that can be done here. So all of your organizations have come out with vocal support for a number of reforms that can help to fix this broken institution in a real way. So I think it's important to spend some time talking about that next. I see lots of questions being dropped in the Q&A section, in the chat session. So I do want you guys to know, like, I plan to make sure we hold some space to lift up some of those really good questions at the end of our agenda here. We're going to keep pushing through, but I see y'all. Thank y'all for remaining engaged here in this virtual space. So one of the things that I want to talk about, each of your organizations has endorsed the Judiciary Act of 2021, which Representative Takano talked about would add 4 seats to the Supreme Court. I wonder if each of you can just talk a bit about how your organization came to the decision to support the Judiciary Act. Christine, can I hear from you?
Sure. As a civil rights organization that litigates and advocates for policies that come before judges for interpretation, Lambda Legal has a vested interest in ensuring that our judiciary can be trusted to administer justice fairly and impartially. We also know that the credibility of our judicial system hinges not only on the decisions that it renders, but also on whether the institution as a whole reflects the diversity of the nation it serves. And we believe that justice delayed is justice denied. Our judicial system cannot function properly if it's understaffed. So all of these interests and core beliefs led us to endorsing the Judiciary Act of 2021. Adding 4 seats to the Supreme Court will aid restoration of legitimacy to the Supreme Court, helping to ameliorate this corrupted confirmation process and improve administration of justice by, again, staffing each federal Circuit Court of Appeals with its own designated justice to consider emergency appeals and handle other matters. And it's not just the Supreme Court that needs more seats. The lower courts need seats as well. They're extremely backlogged because Congress hasn't added seats to the district and appellate courts in years. So as our population grows and we pass more laws that need interpretation, we have more lawsuits. Not to mention, we need more diversity in who issues opinions. Court expansion more broadly can help bring an array of perspectives and lived experiences that are currently missing from the federal bench and our jurisprudence. So I'm also looking forward to our country's first openly bisexual, transgender, or non-binary judge. So yeah, it's pretty simple for us to endorse the Judiciary Act of 2021.
Thank you. Thanks for sharing. Julie, what about you?
Well, I mean, we didn't make this decision lightly, but we, kind of like Christine said, we are a civil rights organization. We exist to protect the rights of historically marginalized people. And it's become all too clear that those rights are just not going to be protected with this Supreme Court majority. You know, we've been doing our work for years under the expectation, or we've taken for granted, that courts aren't going to take rights away. And in Dobbs, it's the first time they actually did that. But this court is making radical decisions and is taking away rights and autonomy from people. And we have to be clear, this decision in Dobbs is it's gonna cost lives, and it's gonna drive people into poverty. The harm is gonna reverberate across generations. It's almost mind-boggling that we have to sit here and think about the fact that many people just lost the basic right to bodily autonomy. We're talking about states literally preventing their citizens from traveling to go get healthcare, like as though they own them or something. It's a crazy place we're in right now, and it has huge implications for so many people. And it's not even just about bodily autonomy. Christine touched on this earlier. It's about money. Being able to access abortion care allows women and other people who can become pregnant to finish college, increase their earning potential. It's an economic justice issue. But of course, the people making these decisions, they can do so easily because they're in a position of privilege, and these decisions aren't going to affect them personally. And, you know, our opponents, I think that we're not going to do anything, that we're afraid, and we won't resort to do the kind of things that they do. I think as progressives, we worry about consistency and staying, you know, inside the box. And but the other side just does it without hesitation. When we look at this, still, you know, almost 2 years later, they're still going on about election fraud just because they lost. And so, you know, Mitch McConnell doesn't worry about hypocrisy and consistency, just about power. And we have to be brave in moments like this. People are going to look back and say, what did we do in this moment? What did we do? And we'll be measured by that. You know, we work for equality, and we can't act like nothing has happened. If they'll take everything away if we don't act. So there's actually power in saying this isn't right. We need a long-term solution to get out of this. And this is part of it. Court expansion is part of it.
Absolutely. Thank you, Julie. Sam, what about your organization?
Yeah, I agree with all of that. The Freedom from Religion Foundation agrees with all that. And actually, back in December of 2020, FFRF released a report on the Christian nationalist capture of the federal judiciary, which you can find by searching FFRF Religious Liberty Under Threat. And so the report documents how, due to unprecedented manipulation, the Trump administration had this rare opportunity to fill 3 Supreme Court seats in one term. And Trump's choices were all religious extremists pushed by Christian nationalist lobbying outfits because of their regressive views. Their pre-Supreme Court records on the Establishment Clause and on other civil rights issues were alarming. And now that they're sitting on the court, we're already seeing the disastrous results. like Christine mentioned, the nation's highest court should better represent the diversity of the US population. Could not agree more, not only by sex and race, but by diversity of legal background and other lived experience. The current 9-member court is dominated by 7 white justices, 6 Roman Catholics, 1 and another former Roman Catholic, and 6 men. It's not representative of the country as a whole, and that has to change. And we've already seen the naked power grab to get the court to its current state. The Judiciary Act of 2021 and court reform in general is a way to correct for that already past power grab.
Yeah, I think you're right. And the idea that is one of the only maybe real material ways to make some corrections to for the power grab that's already happened. So as you guys talked about, each of your organizations also works to litigate cases, though, that could end up before the Supreme Court, not just from the standpoint of wanting to see a court expansion for representation for all of these marginalized identities, but also the work that you all do to represent very specifically people in cases where people are affected by this. So how did your status as a litigating organization play into your decision to endorse court expansion? If that answer is different at all.
I could speak to that. I think adding to what Julie had said. I had only been at Lambda Legal I've only been there for a little over a year now. So I wasn't a member of the organization when the Supreme Court granted cert for Dobbs. So I can't speak to how folks reacted there when it happened. But I've been a close partner of Lambda in the judicial nomination space for years. So I knew that they were in the same place I was when that day came. Donald Trump, Mitch McConnell, Chuck Grassley, and Lindsey Graham were all eroding the legitimacy of the Supreme Court by over-politicizing the confirmation process, abandoning Senate norms, and stealing multiple Supreme Court seats. And the Roberts Court was eroding its own legitimacy by ignoring decades of precedent in Justin and Lake and issuing opinions with faulty legal arguments, creating new legal doctrines out of whole cloth to provide outcomes conservatives couldn't secure via legislatures, and harming our democracy by tipping the scales to favor the few who are powerful instead of rightly belonging to all Americans. And after years of sounding the alarm of the erosion of the court's legitimacy, I had to ask the question the day they granted cert for Dobbs. And even before that, actually, at what point is the Supreme Court illegitimate? And at that point, how do we speak about the court as an organization that petitions the court every year? And it's a question I came to Lambda asking. So when the Supreme Court granted cert for Dobbs, I knew we had to have an answer to that question. My old legal organization needed an answer, and my current legal organization needed an answer. And that leaked Dobbs opinion helped answer it. Dobbs was the proverbial straw that broke the camel's back. That and numerous decisions from this term that were legally unsound, upended long-standing precedents, and were cavalier to the harmful impacts it would bring to the American people. As Julie mentioned, the court for the first time took away a fundamental constitutional right when it issued Dobbs. It decimated the Establishment Clause. It undermined Miranda rules. It crippled campaign finance reform. It cut courts off at the knees when trying to prevent gerrymandering. It inflated individual gun rights, and it gave corporations carte blanche to pollute our planet by making the federal government ineffectual in regulating them. And that was just this term. So when our legal department looked at the history of the Roberts Court, how the court came about to its current assortment of justices, and looked at this term in particular, the answer was clear. The court is illegitimate. We cannot trust it to be the fair and impartial body the Constitution's text and structure requires it to be. Our democracy requires it to be fair and impartial. So Supreme Court expansion for us is only the beginning of the solution, and it's our responsibility as civil rights litigators to keep sounding the alarm and asking for this solution.
I think that is so real and such a real answer. You are right that Supreme Court expansion is just a drop in the bucket to a certain extent. It is just not even the whole bag. I think when it comes to court expansion, I think court expansion at the Supreme Court level and throughout federal courts, as we talk about in our work with Demand Justice, is going to be key when it comes to making sure that we have a court system that the American people can feel a level of confidence in, its ability to be impartial and be unbiased as it was designed to be. And that is what we want. We want that legitimacy restored to the courts. And this is just really a clear way to do that. So as we talk about that legitimacy, most of us have heard about Justice Thomas's wife, Jenny, and her participation in the efforts to overturn the results of the 2020 election. But this is just the most recent example of how the court's lack of ethics rules lead to intolerable conflicts of interest in a lot of ways. When Lambda Legal announced its support for court expansion, it also announced support for ethics reform on the court. Why is ethics reform so important? Christina, Christina, let me hear from you.
Well, ethics reform is absolutely critical to restoring our democracy. There's a reason why all of the lower federal courts have to adhere to a set of ethics rules. Courts have to be fair and impartial for them to play their constitutional role as arbiters of disputes and to be seen as a legitimate body by the people who come before them seeking justice. And courts have to be free of bias in order to be fair and impartial. But how do we know what biases each justice might hold if we don't know what their interests are and the interests of their family members? What boards do they sit on? What stocks do they hold? For which causes are their spouse lobbying? Are they donating to any hate groups? I still want to know who paid off Brett Kavanaugh's credit card debt. If there is a shred of personal gain or detriment that can come about through a case that's before them, a judge needs to recuse themselves from that case in order for it to be judged fairly. So enacting an enforceable set of ethics rules is good governance, and it's a nonpartisan issue. Everyone should want the Supreme Court to be free from bias. There's no reason why it should be the only federal body without a set of ethics rules to follow.
Yeah, I think in this space where we talk about the ungoverned or those who have this idea that they are ungovernable, it is really, really important that we think about ethics reform for some of the most important seats in our nation's democracy. So thank you for talking a bit about that. So just a couple more questions. Sam, Justice Alito recently spoke at a religious liberty summit in Rome and had some rather unkind words for those with whom he disagrees. Can you say a little bit about why that speech was so problematic and how a code of ethics for Supreme Court justices might prevent such a thing like this from happening in the future?
Yeah, sure. So, I mean, the justices give talks all the time, and this is not inherently a problem. They're mostly boring and they get no media coverage. The basic understanding is that the justices won't speak about matters that are likely to come before the court, and that they won't get political when they speak. But for those who didn't watch Alito's July 21st speech in Rome, and you shouldn't bother, it was full of talking points straight out of a Christian nationalist pamphlet. So he begins by pointing out that religious liberty is threatened in many parts of the world, which is true enough. But then he makes the illogical leap to characterizing the religious freedom of Christians as under attack here in the United States. Like, just as a reminder, 7 of 9 Supreme Court justices are Catholic or were raised Catholic. One is Protestant, one is Jewish. Christians are also vastly overrepresented in Congress. 88% of the current Congress identifies as Christian versus 65% of adults in the US. Christians are not political outsiders in the US. They are not powerless, but rather they are receiving favored treatment. And Justice Alito pretends otherwise because he's trying to establish religious privilege for Christian nationalists, the right to discriminate motivated by religious belief, as I talked about earlier. So Alito also goes on in his talk to describe non-believers as the enemies of religious freedom, as if true religious freedom isn't a valuable protection for non-believers as well as religious minorities. Look, what we oppose is religious favoritism, right? The radical redefinition of religious liberty that transforms it from a shield meant to protect religious minorities from the tyranny of majority rule into a sword, allowing Christian nationalists to discriminate against politically marginalized groups. Now, a code of ethics for Supreme Court justices cannot undo the fact that the court has been captured by Christian nationalists, but the public being aware that this is a problem is a start. Ethics reform is certainly a step in the right direction, and court expansion is really the name of the game.
Thank you, Sam. So my last question is for you, Julie. When your organization, joined by Lambda Legal, Transgender Law Center, and BTQ legal advocates and defenders, announced support for court reform, you also called for passage of the For the People Act, the John Lewis Voting Act, Voting Rights Advancement Act, and the Washington, D.C. Admission Act. What is the relationship as you see it between voting rights and Supreme Court reform? And then if you can tell me, how do you see both of them in the greater context of a broader push for democracy reforms as we've talked about?
Sure. You know, as I read pretty much every day now about election deniers taking power in states across the country, I am really frightened about the health of our democracy. And even though it can take time, in the past, I've always felt some degree of confidence that if our public policy strays too far in any one direction, we, the people, have a way to correct that through the ballot box. If that's taken away, then we have no recourse at all. In my personal opinion, I think we have too many of these counter-majoritarian so-called safeguards built into our system, the Electoral College, the filibuster, gerrymandering, and the structure of the Senate itself in a way. And they're being exploited to entrench the power of those with truly minority views. And if we don't protect the right to vote, nothing else matters. The Supreme Court, despite the way they act, are a co-equal branch of government, and they don't sit above the others. And if they're going to insist on adhering to this method of constitutional interpretation that literally reads vast swaths of the population right out of our founding document, then we should and we have the ability to rebalance the court so that it functions in a way that protects all of us. There's nothing sacred about 9 seats. There's nothing sacred about a method of constitutional interpretation that relies on views that held sway when most of us couldn't even participate in the political process. So this court is acting contrary to the interests of the majority, and it's within our power and rights to fix it.
I think, thanks for answering that, Julie. I want to take some time in just a few, or before we wrap this, I know we are a little bit over, to just talk about some of the work that Demand Justice is doing right now as we make our efforts to broaden the efforts, to broaden the support, the Democratic support, especially for the Judiciary Act as a real and viable solution to push that right-wing majority in the opposite direction, to reinstate the support that we know would exist in a Supreme Court and a federal court, that we could be confident in the ability to be unbiased in all of these things. And so I want to talk about some of our action steps. And for those of you who have joined us tonight, the ways that you can move forward in, now that we've heard about some of the things, really taking action and moving forward. But first, I want to just check the Q&A tab for some questions. There's one I want to raise up here. If either of you feel compelled or equipped to answer these questions, feel free to do that. So there's a good one here, I think, as it relates to what we just talked about and some of the other things that you all have supported. Do you think term limits added to the Judiciary Act will also help SCOTUS become more equitable? So what are your thoughts, if any, about term limits as it relates to equity here?
I think there's a particular constitutional problem with trying to term limit Supreme Court justices because the Constitution says they're appointed for life. But I think in general, it's a good idea to explore that, and for the federal judiciary more broadly as well.
Yeah, I would agree. I think it's hard not to get tripped up a little bit on the fact that it would be a lot harder to do that. Although I've heard some discussion about some creative ways around that in terms of maybe creating different statuses, I think that's a word, among the sitting justices. And it really would change the dynamics a lot. I think the process has become so fraught and so partisan because these are lifetime appointments. So there's this push to get younger and younger and more extreme people on the bench. And if there were a way to limit that, it could have a real moderating effect. It's just procedurally a bit more difficult than adding seats, which is, the number of seats, as I think most people know, has changed over time. That's not really that big a deal.
Yeah, as we talk about their current marriage to history and precedent, it is a part of that for this number to be changed to reflect the number of circuits. There are 13 circuits, right? So the idea of adding 4 more seats is just not that far-fetched. It's not a crazy idea. And I think it is a really, really viable option. And like you said, term limits are a thing that can help. They are a thing that we know may not be an easy thing to lift either. And one of the things that beyond what we can do to combat really, really strong right-wing folks who are young, getting in and making lifetime commitments to really bad decisions that stand to threaten all of our rights, is how we as an organization, Demand Justice, will work and has been doing the work, I think, over the course of the last couple of years to make sure we're supporting and just shedding light on professionally diverse candidates for these judiciary seats across the courts, across the federal courts, not just to the Supreme Court, but in all of those seats, not just people who have only served as prosecutors, not just people who have one particular mindset when it comes to the way that they plan to think, the way that they plan to be a judge in those roles. So I think term limits, I think thinking about how we are able to elect and appoint more professionally diverse folks is another way that we can think about that. Looking in the Q&A section here, for one more. Yeah, and so thank you. I see that there were a couple of questions answered by panelists already. And so how can or will the legislative and executive branches combat the corruption we're seeing from the judicial branch? Thank you, Christine, for answering that. Ethics reform. As you talked about, Sam, there are a number of ways, right? There are a number of things that are touched by that. That could not necessarily be a one-stop shop, but in a lot of ways provide some barriers to entry and some checks and balances when it comes to who these people are and how all of their identities show up and how they make these decisions too. So I think that's another thing to really think about. I want to thank you all so much. I know we are over your time, so I'm so grateful for all of you, for all of our partners taking the time to jump in, for all of you who have joined us today. I hope that this has been a good resource for you, both to talk about just the stage as it exists right now, what that sense of urgency looks like in a real way as we talk about the lives of folks who live and walk among us and all of us who are here tonight on this call, and then also thinking about the things that we can do moving forward. So as we work to broaden support for the Judiciary Act, which is a really game-changing bill, like I said, adding 4 more seats, something that you all can do right now, you can work to call your member of Congress, to send a letter to your member of Congress, and make sure that they know that you are in support of the Judiciary Act. As we said, this is not a thing that doesn't follow the history and precedent that we'd love to see. It's been expanded before, it can be expanded again, and it needs to be proven to every member of Congress that the support for this across your constituency does exist. So wherever you are, the first thing that you can do is make sure that you are showing the groundswell of support. We are organizing, as an organization, petition delivery events throughout this summer to the offices of members of Congress, both who we've met with and who we've pleaded and tried to meet with over the course of the last couple of years, in an effort to just make sure that they hear from their constituents about why this is so important, about why it has the ability to impact their lives, in a way that we really need to see them take action. We're also partnering with other organizations who are doing really, really strategic actions, who are doing those events both on the Hill and in district offices across the nation, organizing their bases of folks who are always really, really involved and already doing the work. We know that folks are fighting. We know that folks are in your communities standing and doing all of the really important work for democracy reform in general. And this is another one of those things, right, to add to your tool belt, to add to the agenda for the years to come, and a thing that we really, really need to fight for. But I hope we framed here for you tonight some of the reasons that this is really, really important. And we can't stand to not let this be a priority. If you are here and you're interested in continuing to take action, you can go to demandjustice.org/volunteer. There we can get you signed up. A member of our team will be able to reach out to you wherever you are in the nation and talk about what we need to do to move your member of Congress specifically, if they have not already co-sponsored this piece of legislation, and the work that we can do in a greater way as a community to work to very specifically address and fight the attacks against the LGBT community as we see are manifesting through this incredibly captured Supreme Court. Thank you all so much for being here. Thank you for your time. And I look forward to remaining in this work with all of you. Y'all have a great night.